And with that, we will call our first case for the morning, Malone versus McRell. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive. If you are going to reserve time for rebuttal, we ask that you keep track of that time if we do not use it up. And you may begin when you're ready.
May it please the court, Steve Hicks, on behalf of the plaintiff appellant Heather Malone, I will reserve 2 minutes for rebuttal, or at least try to. The court's asked 2 questions, that 2 questions be addressed at this mini oral argument on the application. Those 2 questions are pretty simply stated. To paraphrase them, the first question is whether MCL 600-2925D, as amended in 1995, abrogated the common law vicarious liability rule that releasing the agent releases the principal. Second question was, if not, should this court abandon the common law vicarious liability rule that releasing the agent releases the principal? The answer to both questions would be in the affirmative, but if I can start with the first question, the reason the answer is yes to that first question is that the statutory wording of MCL 600-2925D sub A, it's clear, it's unambiguous. It says that if a release, and I'm going to use release here, it also says covenant not to sue or not to enforce a judgment, but I'll use the term release as that's what the court used in their question. If a release is given in good faith to 1 or 2 or more persons for the same injury or the same wrongful death, it does not discharge 1 or more persons for the same injury or wrongful death unless its terms so provide. Here those elements are all satisfied. There is, well, we argue about whether it's a release or covenant not to sue, but it doesn't really matter for purposes of this statute. It was given in good faith, there's no question about that. It was given to 1 of 2 or more persons. It was given to McRell, not Jetman. It is for the same injury or wrongful death. And it says expressly in the settlement agreement that was reached at facilitation, however you want to characterize that, whether you want to call it a release or a covenant not to sue, it expressly says that it's not going to affect the claims against Jetman. So there's no question that the wording of this statute applies. And frankly, there's no alternative take on it. The Court of Appeals did not give us an alternative reading. Defense counsel has not given us an alternative reading. The fact is the statutory wording compels the result that we're seeking in this case. It can't be read any other way. And when the statutory language is clear, this court has told all of us time and time again that it should be applied as written, that is the legislature's intent, that is the best expression of the legislature's intent. So I think the answer to the first question is clearly yes. But if this court disagrees with me and moves on to the second question, concludes that I'm wrong on one, we can look at whether, the question is whether the rule should be abrogated regardless of MCL 600-2925D. The fact is the rule no longer serves its purpose. If you research this rule, you will find that the purpose was to avoid double recovery. But the fact is there's no ability to get a double recovery in our system because of set-off rules that exist, whether you're looking at whatever context you're looking at. You can only recover once for your injury. That principle has been well established in Michigan law time and time again.
But counsel, obviously the whole notion of agency, I mean, it permeates the law beyond just obviously this context. You can go into employment law and agents and vicarious liability. It's a core part of employment law. So, I mean, I guess I'm wondering, how does that hook still need to exist? I understand your interpretation. I think you have a good argument. But I also can understand the other side's argument that to get to the person to be liable, there needs to be some sort of a hook. Why don't we need that hook?
It certainly is a hook. I guess the question would be, what's the justification for it at this point? The justification historically has always been double recovery. That isn't a concern in any of the contexts that I've looked at, although I don't recall that I looked at employment specifically. What are the downsides of having this rule? Well, discourages settlements, so you keep defendants in the case when they clearly don't want to be in the case, would like to be out of the case, don't want to pay for attorneys. It wastes courts' resources because it makes things more complex in moving towards trial. Most importantly, for my clients, it delays compensation to injured persons in the cases that I litigate. And then last of all is what I would call the Justice Levin concern, which he expressed in Theopolis. It does create a trap for unwary litigants. And that's essentially what happened here. A settlement agreement was reached at facilitation, which often happens. The facilitator drafted up an agreement, and the plaintiff said, "I'm okay with this. We'll accept the 50. We'll let you out, but we'll only do it if it doesn't affect the claims against Jetman." And that ended up being the problem for them.
If the principal is not released from vicarious liability through the release of the agent, is there anything to prevent the principal from seeking indemnity from the agent?
From seeking indemnity from the agent, that would go to, I don't think it's really indemnity. I think it's more a question of contribution. That the agent would, the principal ended up paying it, but the 629.25D sub B, I believe it is now, deals with going after other defendants and saying, "Hey, I paid this whole thing, but it really was you."
But the principal's only liable for the agent's acts, right?
Correct.
So it seems to me it's more indemnity than contribution. Is there any way that an agent can settle a claim without ensuring the principal's not going to come back after them?
I don't believe they have any standing to come back after him as a vicariously liable defendant. I haven't seen a case where they were able to do that because the law establishes clearly, and nothing is changing with that rule, they are vicariously liable under the respondeat superior doctrine. I haven't seen any cases that would say, "Hey, yeah, we know the common law holds us responsible and we know we have to pay this, but we're going to come after you." I haven't seen a defendant be able to do that. I haven't given a lot of thought to the reasons why they've not been able to do that. Maybe defense counsel could address it better.
Is it not the agent's action that is the negligence?
Certainly it is, yeah. But it's imputed to the principal. No one's questioning the common law of vicarious liability or respondeat superior. That's not an issue in this case. The only thing that's at issue in this case is whether there is this corollary rule to vicarious liability that says if you release the agent, you release the principal. So I guess your question is, could the principal in theory go after the agent and say, "Hey, you only paid $50,000, but we didn't do anything wrong. You were totally to blame. You owe us $1 million," or whatever the judgment ended up being. I don't think that works in Michigan law for various reasons, but not having worked the defense side, I don't know that I can give you a definitive answer on the wheres and whys of that. But common law vicarious liability isn't changing here. It's just this rule.
Is it important that the settlement agreement, we'll just call it that, carves out that, that the employer, that hasn't been settled? Is it important that that specifically be set forth in the release agreement or covenant not to sue, or whatever we want to call it? Is that important?
Not if this court gets rid of the rule, it would be less important. What you can do is, because 629.25D says, unless its terms so provide, you could get rid of them as well. You could make it clear that, we're doing more than that. Belt and suspenders, I would always do it. I would always put it in there. But if the rule's gone, then in theory, you don't really need it. And you don't need to designate. We don't need to have this battle over, is it a release? Is it a covenant not to sue? What was the intent? Those are the battles we've had for years, and we've had them ever since Theophilus, because if you look at Theophilus, Justice Boyle only joined that plurality because she agreed that the rule was still there at that time, before this amendment. She agreed with that, but she said, "I'm unclear on the intent here. We should go back to the trial court on remand and figure it out." And that's what Justice Krauss would have done in this case as well. But if you get rid of the rule, you get rid of that problem. It basically just says, listen, you're different defendants, there's no reason for it. And that is consistent with what most states are doing.
What do you make of the Court of Appeals analysis when we asked them whether the 95 amendments had abrogated Theophilus, that when they said that it only was intended to address joint and several liability and not vicarious liability?
What do I make of that,
Yeah.
that argument? Certainly, that was one of their intents in doing that. I mean, it was a comprehensive tort reform package. There were a lot of things going on in it. But the notion that the Court of Appeals puts into their opinion, and that defense counsel also argues, that you have to expressly say, hey, we're abrogating this law. I looked for cases. They say there are statutes out there where it reflects that. I can't find them. The only thing I found that was close was the no-fault amendment, where they said, we're adopting McCormick. We're basically codifying McCormick, and they used it by name in an enabling section. It's the only time I've seen it. I'm sure there are.
What is the interpretive standard that applies to when we should? It's a question of legislative intent, and we've said at various times. You know, the legislature, when it abrogates the common law, it should speak in no uncertain terms, or it should do so clearly, and so forth.
Correct.
It sounds like a clear statement rule.
Correct.
At least a type of clear statement
It's
rule.
never been interpreted that strictly. In fact, the Court of Appeals has not done that. Even Judge Swartzel, who was on this panel, did not do that in a case that he heard after that. And the
But
reason,
what is
the
the
reason you,
what is the
well, the
standard? What is the standard is my question to you. What
I think you're
standard should
right.
we
I
apply?
think you've stated the clearly abrogated standard is the standard. What could be clearer than taking out the one operative word in the Theophilus opinion, tortfeasor, removing it, putting in a different word that's broader? This is very different than Velez versus Tuma, where a whole provision went away, and the
But
court said,
you're not answering the question.
the standard?
I'm getting to the end of my time on the court, and from time to time, we've.
No, I agreed with you on the
I think I
standard.
pointed out in Mimic, when I wrote an opinion there in a footnote, that, we've looked at this differently. There's another abrogation theory about when there's a comprehensive statutory enactment, it might replace all the common law in a certain area. We're not in that situation here, I don't think. The question for us, though, is, I think you're saying, I don't think the statute has to say the common law is abrogated, right?
Correct. It has to
Okay,
be clear from the statutory
So what does
word.
it have to say or do? Does it have to be by necessary implication? In
Yeah,
other words,
well, for example,
the clearest and only implication from the language is that the common law is abrogated? Or is there a different standard? I'm going
Yeah.
beyond your case to
I
say what
understand.
standard should apply every time this court has to make this kind of an assessment.
I'm sorry, I'm running out of time, and I want to make this point.
filibustering.
You may be, Justice Viviano. and I
I'm allowed to
suspect-
do that for one
The,
more day.
The clearly abrogated standard is pretty clear, but there are also other rules that go with it. Is there a conflict between the statute? If so, then the statute should control. There is a clear conflict here between the common law rule and the express language of 62925DA.
Is it the
It
only
can't be
reason they
resolved.
might have made that change is to abrogate the common law, or are there other reasons why the legislature might have made that change?
Are there other reasons why they might have made that change? None that are expressed in the legislative history or any place else that I've found. When you take out the very word that's the operative word that resulted in a 4-3 decision, I don't think you can have anything clearer than that. And certainly courts, and I've cited a few of them, the Court of Appeals in many instances has said something was clearly abrogated on much flimsier evidence than this. One last
Can I ask
thing.
you one question? I understand Theophilus sort of hung on the use of the word tortfeasor.
Yes.
Can a vicariously liable principal, aren't they in fact still a tortfeasor? They're passive as opposed to an active
The court said no in
tortfeasor? The court
Theophilus.
said no,
Yeah.
but,
I don't think in the common parlance of tortfeasor they are.
okay.
I don't think so. If I can address one last thing, because
Well, you have 1 minute left, so.
I know, I'm not going to have any rebuttal, but this is going to come up on rebuttal anyway. The gist of their argument is, you ask two questions, good questions, but you don't really need to get to them because of the dismissal with prejudice. That they say was an adjudication on the merits, therefore game over, don't worry about the release. They're fundamentally wrong on that, because this was a voluntary dismissal. Voluntary dismissals are different than involuntary dismissals. They rely on El Shamari. El Shamari was an involuntary dismissal with prejudice. Al-Shamari relied on the court rule, MCR 2.504B3. That's not this case. This is a voluntary dismissal. It may be an adjudication on the merits, the courts have said that, but it is not an expression, as defense counsel would tell you, of no liability. If that were true, we would have no liability expressed simply through someone filing a suit, dismissing it, filing it before service, and then filing again and dismissing it, because that is an adjudication on the merits under 2.504A1, voluntary dismissal as well. So I just wanted to make that point because I think that's where their argument goes. I thank you for your time.
Thank you.
Good morning, may it please the court, Robert Goldstein on behalf of Zietman Brighton. Opposing counsel's last point is my argument. This is not a case to decide this question that has been, or the two questions that have been posed. And I'll say it, as I said in my brief, this was an adjudication on the merits of the tortfeasor, because, yeah, a voluntary dismissal, but it was with prejudice. And I cited all the case law it talks about. This is an adjudication on the merits of the tortfeasor in the case, allegedly. But now that tortfeasor is gone, and all we have is vicarious liability in this case. Now, as I went through the history of this case in my brief, there were tortfeasor allegations against my client. Those were dismissed on summary disposition, not appealed, and those are gone. So all we're left with was respondeat superior. Plaintiff decided to enter into a settlement with the agent, but at the same time, and the statute talks about release or covenant, it doesn't discuss the situation we have here, where the agent is dismissed with prejudice from the case involving the principal, and the only liability potentially on a principal is through a vicarious situation and no act of negligence on the principal's part. So when you talk about the two questions, that the release or covenant, where the statute talks about what a release or covenant does or does not do, well, that's one part of it. But in our case, we have something beyond the release and a covenant. We have this adjudication on the merits and the dismissal of the agent, leaving just the my client, the principal, as a defendant right now. And that's what prompted the summary disposition motion under standard principal agent rules. And so I guess when I say that this is not the case to even discuss whether or not the effect of that statute, the other point is, I think by the questions that were posed by the court, it seemed to suggest that now you're going to take on the entire area of principal agency relationships with this, I'll call it a peculiar case, but that seems to be what the suggestion is. And this is not that kind of a case where you're going to necessarily have to rewrite the entire principal agency relationships arena.
Help me understand what you mean by that.
Well,
I mean, if the question that we've asked is, did the 1995 amendments abrogate Theophilus? And we can answer that by saying in the affirmative that by taking out tortfeasor and putting in persons that it did. So where are you going to the next step where we'd have to rewrite agency
well, I'm
principle?
saying that in this particular case, it seems like you're talking about having to actually establish or look at the other rules involving principal agency relationships beyond the release or the covenant. That's what I'm trying to say. Did this abrogate that rule? I don't think that's what happened. I went through the brief, and I don't think that's what happened. And we've had several decisions now from the lower courts and the Court of Appeals that agree with that. That's not what the purpose of this statute was. And again, it was a whole area of reform, tort reform, that was going on. And I think in this particular situation, what we have involving really a principal-agency relationship is a point of liability here. I don't think this is the case to consider that.
So what did the removal of the word tortfeasors and the insertion of persons, what was the impact of that then? If it didn't do what opposing counsel is saying?
Well, obviously, it changed what they wanted to get either more specific or perhaps broaden it. I'm not sure. I mean,
But that's what we're here to talk about, is what that means, what that language means. We
Well,
can't just ignore it and say, well, legislature might have done this, it could mean different things, but we're gonna ignore it because we'd have to look at other areas. They might not have done it on intentionally, but they did change those words.
They did change the word. And I can't tell you exactly what their intent was with that. I mean, obviously, it's a different scope of person or entity that's being included, I guess. But I can't say more than that.
Why does it matter, or what's the difference, like, talking either in this case or in the broader context? I think you'd agree that if it was done in a covenant not to sue, that's fine. There aren't the concerns about releasing the agent, you can
That's
still
true.
go against the principal and all of that. So the concerns about releasing an agent when the principal's still liable and the potential, all of the things that might be associated with it, as long as it's in a document labeled covenant not to sue, as opposed to a release, like why do the concerns about the releasing the agent not exist in a covenant not to sue?
Well, the agent still potentially, can be potentially in the case then.
How?
With the principal bringing that individual or that entity into the case.
And that's what is advanced by having a covenant not to sue?
It's a different, yes.
Like as a non-party fault?
Yeah, you
how
can
do
bring
they
them in
it
on a non-party at fault, sure.
Okay.
So again, that's the thrust of my argument here. And I've gone through both those questions in the brief that based on the statutory language and the rules, which Justice Viviano was concerned with, we've got to be very careful with in interpreting these statutes and abrogating the entire common law in this particular area. And I went through that analysis in my brief. And I think, but more importantly, which is really the thrust of this argument, is this, even if it wasn't abrogated, then this is not a situation where it should be allowed to give that the abrogation should be in a situation where we have today. Because again, we have a peculiar case where the beyond the release and covenant is what I'm saying. We have a dismissal with prejudice of an agent, the negligent agent, I guess, is what you'll say, but that agent is now gone, and the principal was sitting there. The only liability left was the vicarious liability, and the agent was now dismissed from the case with prejudice, which is an adjudication on the merits.
It might be an adjudication on the merits, but I'm struggling, meaning that the plaintiff could not file another suit against that individual. But I'm struggling to find the connection between saying an adjudication on the merits, particularly for res judicata purposes, is the equivalent of a finding of no liability.
Well, I think
Because you need a finding of, you need that dismissal with prejudice to signify that there is no liability on the part of the agent. And a voluntary dismissal with prejudice, I don't know that it says anything other than the fact that the plaintiff can't come back against that person in a subsequent suit.
Well, it is an adjudication.
It's an adjudication,
it's
but
an
isn't it an
adjudication.
adjudication of no liability?
It is an adjudication of no liability because it's a dismissal with prejudice as it stands. That is what it stands for.
Isn't all you need for res judicata purposes is any final judgment, whether it's liability or no liability?
Well, you could have a consent judgment, sure. I think consent judgment would be
Or a judgment after a jury verdict. You just
Or a
need a
judgment
final,
after a
you
jury
just need a
verdict,
final
yes.
judgment, and then for res judicata purposes, the issue's been decided, right?
Yes.
As long as it's a final judgment.
I'm sorry.
As long as it's a final judgment. I
Yeah,
think.
final judgment would be res judicata after a jury verdict.
When there's vicarious liability based on agency relationship, does that mean that the agent and principal are jointly liable?
Are jointly liable? It's a derivative liability from the agent to the principal. The only way the principal is liable in the first place, at least now with the actual tort claims dismissed in this case, is through derivative, that the negligence.
You're changing the question. Is vicarious liability and joint liability the same?
No.
Okay. Why not here?
In this case, again, there's no negligence on the part of the principal here, whereas the agent was the negligent entity. And that's the negligence that is derivative to the principal. That's all. That's the only reason the principal's even here, is because this is a pass-through to the principal.
So the agent's negligence is a condition preceding the liability
Right.
on the...
Right.
And that's why you say a dismissal with prejudice establishes that there can be no liability on the agent,
That's-
therefore there can be no liability on the principal.
That's the argument, yes.
So what happens if we were to say that the plaintiff can proceed against your client?
I'm sorry, just,
What if we were to say that the plaintiff can proceed against your client, it goes to judgment, there's a money judgment against your client, what happens to the $50,000 that the agent paid your plaintiff, or paid the plaintiff?
well, I think there would certainly be an argument of a set-off.
So there isn't a risk of your client or the principal having to pay something either to the plaintiff or on behalf of the agent, right? It's a set-off from your liability.
But our liability in this situation is completely derivative of the agent. of the
Right, but
agent.
you wouldn't have to pay, say there's a judgment for $100,000 against your client. Do you get a set-off of the $50,000?
That's certainly an argument, and, yeah, we would make that argument, certainly, I mean. But I don't know how that would all work out. But, yeah, we would make the argument that there would be a set-off. But again, then we get into these factors of the reasons for the plaintiff settling or the agent settling the case for that lower amount. And that's why that's why the agent has to remain in the case in these circumstances where there's a vicarious liability claim. That's the only basis for the action against the principal. I think that highlights the point, though.
Would the principal have an action against the agent for the excess amount?
Well, I think it would be, I don't know, it would be contribution. As far as indemnity, which I think was your question, Justice
Yes.
Zara. I suppose if there was a contract in place between the principal and agent for something like that, there would probably maybe contractual indemnity, I'm not sure. As the common law indemnity, as you know, is very difficult to obtain common law indemnity. So I can't answer it directly. I guess it's out there as a potential, but I can't answer it directly because I simply don't know.
Getting to the common law question, Price versus High Point Oil was a unanimous decision of this court, I think in 2017, that set forth when the court should look at common law and the gradual steps in how we change common law and whether we should change common law. Both sides seem to be arguing that it's in you say keeping the common law, plaintiff says changing the common law would be in the best interests of the state of Michigan. Give me your arguments why your position that we should not change the common law serves the best interest of the state of Michigan.
It's not in the best interest because you're, in a sense that one person could be in a position where, as a principal, they can no longer control an agent who settles the case, and they don't have that agent available for a trial, for example. They don't have the agent available any longer to assist in defending the case. I think that is a big issue. I mean, now that the agent is now settled, there's no incentive for him to come in and argue the actual negligence, whether or not he was negligent. I mean, so that's a tremendous disadvantage to a principal. Now that the control is no longer, principal has no control any longer in trying to defend the case in the sense of the actual negligence of the agent that potentially created
Wouldn't the
it.
principal be arguing that the agent wasn't negligent?
Pardon?
Wouldn't the principal be arguing whether the agent is there or not, that the agent wasn't negligent?
Yeah, but
And therefore, you're not vicariously liable. I think the danger would be is if the agent was in fact still there and sort of was saying, oh no, I was, you know, like in the dram shop cases, right? Colluding with the plaintiff, trying to say that it's not, their presence is potentially more risky to the principal, because the principal will still have the same motivation as it would whether the agent is there or not to argue that the agent wasn't negligent.
I respectfully disagree with that, Justice. I think having the actual person present at trial and throughout the proceedings is critically important, the actual tortfeasor. Whether that testimony is good or bad, that's a different question. But having that person there, having that person in a courtroom, if it has to go to trial, is critically important in defending the case.
Okay.
If the agent, the tortfeasor, is not there, that certainly is not a good impression on a jury.
Thank you. Thank you both. The
Thank
case
you.
will be submitted.